Court is tasked pursuant to TCA 40-35-114 and TCA 40-35-113 to first find whether enhancement and mitigating factors which are confined to these two statutes are applicable. The state urges a number of different enhancement factors. There's a couple that I'm going to rely upon because I think they're just glaringly obvious in this case. And while I could find perhaps other enhancement factors, I don't think there's any point in muddying the record up on appeal with going into those, because there's no specific set of enhancement factors. There's no calculus or graph that the court has to follow as far as I can only go up so far if I find one versus finding five. That's not what the law says. Ms. Howington, this is a strange case. This is one of the more unusual cases among the hundreds that I've tried as a lawyer or as a judge. But there are a couple of things in this case that are just glaringly obvious. I agree with what General Good just said a few minutes ago. You are not the victim in this case. You have a previous history of criminal convictions or criminal behavior. What you had before the night that this tragedy occurred was not very significant, although you were engaged in the trafficking of illicit narcotics, and the court can consider that. But I really don't know how you could have made this much worse than what you did that night. Within literally minutes of when your daughter had been shot and killed, you were attempting to hide the firearm that was used to kill her. You're not concerned, you weren't then, you're not now. You're not concerned with trying to protect Gavin. You're concerned with trying to protect Gavin's mother. And you have been, you were that night, and I will believe that from this point forward. I don't know how you could interpret this evidence any other way. You have a previous history of criminal conviction, criminal behavior. You tried to hide the gun that was used to kill your daughter while her body was still warm. When you were taken to UT Hospital to be checked for shock before you spoke with law enforcement, you attempted to solicit another person to take your cell phone so that it couldn't be looked at, and then you tried to destroy the cell phone. Within seconds, if not minutes, of when your daughter was shot and killed, you're calling 911 and making up a story about how it all happened. And repetitively, I quit counting at about 20, repetitively throughout hours worth of police interviews, not just that night, but on other occasions as well, you made up story after story after story. And this court can consider every bit of that as criminal conduct. So you clearly have a previous history of criminal convictions or criminal behavior which enhances your sentence in this case. As to count two, the aggravated child neglect where there was serious bodily injury, count enhancement factor number 9 applies as well. A firearm and your handling of that firearm is the reason that your daughter is not here now. It's not because Antoine Oliver showed up 2 days earlier. It strains the bounds of credulity to believe that your boyfriend just laid that gun down where a small toddler could just walk in within 2 or 3 minutes after you and your children arrived home, found the gun, pointed it at your daughter, and pulled the trigger when that gun had been in that same place for 24 to 36 hours and nobody saw it. I will never believe that. And I don't think you were honest with the jury about how that happened. But the simple fact remains that however he found it, you were responsible for that gun. What I believe happened, if in fact it was your child that had the gun, when the bullet was fired that killed your daughter, there was a man that came in. And I don't know if it really was somebody to collect window tint payments like you testified to, or if it was a pill deal, but somebody came in. It was a strange man in your house, and I believe you had that gun out for protection. I believe you had a round chambered and the safety off, and that gun was left there, and when you stepped out to smoke, the tragedy occurred. But that's on you and nobody else. So I place great significance on the two enhancement factors that I found. your history, as well as the firearm use in this case. As stated previously, the mitigating factors, this was an unusual case. There are unusual circumstances, but I don't place much weight on that as far as mitigating your punishment. So if you would, please, ma'am, stand up. Ms. Howington, in docket number 117659, based upon the jury's verdict of guilt, finding you guilty in count one of the lesser included offense of reckless homicide, you were found guilty of that offense and sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range 1 offender. In count two, based upon the jury's verdict of guilt, finding you guilty of aggravated child neglect, you were found guilty of that offense and sentenced to a term of 22 years to serve within the Tennessee Department of Correction as a range 1 offender. In count four, based upon the jury's verdict of guilt, finding you guilty of false report, a Class D felony, you were found guilty of that offense and sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range 1 offender. In count five, based upon the jury's verdict of guilt, finding you guilty of tampering with evidence, a Class C felony, you were found guilty of that offense and sentenced to a term of 5 years to serve within the Tennessee Department of Correction as a range 1 offender. And finally, in count six, based upon the jury's verdict of guilt, finding you guilty of attempted tampering with evidence, a Class D felony, you were sentenced to a term of 3 years to serve within the Tennessee Department of Correction as a range 1 offender. These sentences will be served concurrently, one with the other, for a total aggregate sentence of 22 years to serve within the Tennessee Department of Correction. And as your attorney has pointed out, the service rate is at 85%. I wish we weren't here. I know you wish you weren't here. Mr. Oliver wishes that we weren't here, but you're the one responsible. That'll be the judgment of the court. Good luck to you. When do we need to set this for motion for new trial?
Doesn't need a transcript. I suspect that's going to take.
That's going to take a while. She's really backed up. I mean, why don't we set this out about 5 to 6 months just for status on, see where the transcript is, and then we'll set another date, a firm date for motion for new trial. Let's look at what's the first Friday in September.
The 6th.
What about Friday, September the 6th?
That's all I have.
Is that a good date?
Yes.
All right, 9/6 for status, and then we'll be sure and get your motion for new trial filed within the next 30 days, Mr. Whalen.